You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions. Do you understand each of these rights that I have explained to you?
Yes, I do.
Now, with these rights of mine, you want to talk to me about what's going on today?
I'll give you a couple updates on your mom. Okay, we've got her. She's going to be going to jail tonight.
Why?
Okay, she would hit a bunch of cars in the parking lot, and she's real drunk. So, yeah. Is there anybody else that can come hang out with you, or are you good by yourself?
I'm good by myself.
Okay. Sorry to give you this news, man, but it just kind of is what it is.
The woman was charged with 1 count of DUI, 1 count of leaving the scene.
The footage opens with the subject already on her feet in the parking lot. The initial officer commands her to stop and turn around. She denies the allegation immediately and continuously. Under Terry v. Ohio, an investigative stop requires only reasonable suspicion, not proof of guilt. Multiple witness calls reporting a vehicle striking parked cars, combined with the officer's own observation of the subject at the scene, supply that threshold with room to spare. The subject's repeated denials do not dissolve reasonable suspicion. The officer proceeds to place her in handcuffs, pending investigation, a permissible restraint during an investigative detention where flight risk or safety concerns are present. In the patrol vehicle, the subject immediately complains that the handcuffs are too tight and claims they are causing injury. The officer's response is direct. They are tight because she pulled away during the cuffing process. This matters legally. Courts have distinguished between handcuffs applied maliciously tight and restraint tightened as a direct result of a subject's resistance. Under Graham v. Connor, the force analysis is objective, judged from the perspective of a reasonable officer at the moment of application. The officer does eventually agree to check the cuffs and loosen them once the subject settles. That adjustment is the correct protocol and diffuses a potential excessive force claim.
Say John, 10-12-434.
Loosen my... How's that?
All right, turn that way. You're not getting out. Turn that way. Put your foot back in.
Can you pull...
I'm looking. I'm trying to see how tight they are.
They're really tight.
Okay, turn that way. Straighten your arms for me.
I am straightening my arms.
Don't do that. Bring your arms back.
I am.
Bring your arms back.
Are tight.
All right, they're not too tight. I haven't had a chance to look at her car. But if she's hammered, I saw her driving. So.
Yeah, we got some threat damage right here.
Yeah. Oh yeah, fantastic.
Why did I do that?
I told you hit a bunch of cars in the Durban Pavilion parking lot. You got damage all over your car. We got a
damage on my car for previous accident.
Yeah, we got a bunch of witnesses. Okay.
Who's the accident?
A bunch. A bunch. So we're gonna deal with it shortly.
That's fine. That's fine. I didn't hit a single car.
Well, a bunch of people said you did.
I did.
And we got it on video.
Where? Show me the video.
You'll see it.
Show me the video.
You'll see it. Don't worry. Don't worry.
That's fine.
That's fine.
With the subject secured, the officer examines the vehicle. The footage captures what appears to be significant damage across multiple panels. The subject attributes this damage to a prior accident, a Mercedes-Benz collision from 2 months earlier. The officer responds that witnesses observed the impact and that the incident was captured on video. Physical evidence, eyewitness testimony, and surveillance footage form the evidentiary triad in hit-and-run cases. The subject's prior accident explanation is a defense that will be tested against that triad, not at the scene, but in a courtroom.
Please loosen these earphones. They're super tight.
I tried, but you weren't cooperating with me, okay?
They're hurting me.
I was trying, but you weren't cooperating.
Next time. Well, my name is Deputy Evence with the Sheriff's Office, and I smell a strong odor of alcohol coming from your breath. You've been drinking? Well, since you hit a car, you're involved in a hit and run. Okay,
I never hit a car. They never pulled over. No one did anything. That's what I'm saying. Like,
well, they saw you.
Okay, if they would have pulled me over, I would have said something the whole time.
Okay.
That's what I'm saying.
Well, here's what I'm going to do.
Okay.
I'm going to conduct a criminal investigation for DUI. Okay? And since you were seen driving a vehicle, I want to make sure that you're okay. Okay, so what we're going to do, so what we're going to do, So what we're going to do, we're going to take them off, and then we're going to do some what's called field sobriety tests. There's a nice white line over there.
That works.
Come on out, young lady.
I can't.
What's your first name?
You can step out.
Anastasia.
Yes, sir.
Go ahead and step out. I'll take them off.
So bad.
I'll take them off for you, okay?
No. Hold on.
You okay?
No. I'm naked.
Okay, well, I don't need to. Well, how about we pull this up for you? We don't want you to be naked. Okay? Go ahead and turn around. We'll take them off for you.
A second officer, Deputy Evence of the Sheriff's Office, now takes over the investigation. He identifies himself and announces the shift in focus, a criminal DUI investigation. Deputy Evence states he detects a strong odor of an alcoholic beverage emanating from the subject's breath. Under most state DUI statutes, the detection of an alcohol odor by a trained officer, combined with observed driving behavior and witness reports, establishes probable cause for further investigation. The subject disputes the characterization. She will have an opportunity to raise that dispute in court. At this moment, Deputy Evence has sufficient grounds to proceed. Deputy Evence makes an important decision here. Rather than proceeding directly to arrest on DUI, he removes the handcuffs and offers the subject an opportunity to demonstrate sobriety through Standardized Field Sobriety Tests, what the National Highway Traffic Safety Administration calls SFSTs. These 3 tests, the horizontal gaze nystagmus, the walk and turn, and the one-leg stand, are the nationally validated battery for detecting alcohol impairment. Critically, SFSTs are voluntary in most jurisdictions. An officer cannot compel participation. The tests are also admissibility dependent. Courts have consistently upheld properly administered SFSTs as evidence of impairment. The key word is properly administered. Any deviation from NHTSA protocol can, and frequently does, affect whether that evidence reaches a jury.
Thank you.
All right, when I tell you to do so, what I want you to do is put your right hand on top of your head until I tell you to take it down, all right? All right. All right. I appreciate your cooperation.
Thank you, babes.
Babes? I haven't been called that in many years.
Because I'm
Babes.
a dancer. I'm a dancer.
You're a what?
Dancer.
A dancer? What kind of dance?
Adult.
Huh? Adult dancer. Okay. Nothing wrong with that.
I got him.
We all have to make a living, right?
I sure did.
All right.
Okay.
All right, so what I need for you to do is I need for you to come over here with me, and we're going to make sure that you're okay. Do me a favor. See this line right here? What I need for you to do is put your feet together. Tell him I'm sensitive.
Who there? Somebody calling you?
Brent.
I got it.
So you don't want to do the best that I've asked you to do. Okay. At that point, you are going to be...
The test is interrupted almost immediately. The subject announces that someone is calling her. Whether this is a distraction tactic or a genuine concern is difficult to assess from footage alone. What is clear is that the walk and turn was never completed. Deputy Evence's response is measured. He states that at this point, she is being placed under arrest. This is a legally significant pivot. Absent a completed SFST battery, the DUI arrest rests on Deputy Evence's observations alone, the alcohol odor, the erratic driving behavior reported by witnesses, and whatever he observed of the subject's demeanor and physical condition. Courts have upheld DUI arrests on officer observations without completed field tests, but it is a thinner evidentiary foundation.
Placed under arrest.
All right,
Yes,
man.
ma'am. I will be gentle. I'm always
Hey,
gentle.
stop. You're being
I'm always gentle.
Okay.
Okay.
All right?
All right.
Thank you.
I'm always,
Okay,
always
sounds good.
gentle. Okay?
Yeah.
And I'll put these nice and
Yeah.
loose on you so they
Thank
won't
you.
hurt your wrist. Okay?
Thank you. You're amazing. Thank you.
We're here to help you.
I know you are. You're being nice. He was not being nice. You're being nice.
Who wasn't being nice? My boss? My boss is a super, super nice guy.
You're super nice. You're being super nice. Okay. Oh my God. Hold on. Stop. My shit is flying up. My is up.
I don't need to know anything about your
Can someone like...
stuff.
We're working on it.
No. Can you like...
You're good now.
We moved you so the wind doesn't blow where things can be shown.
Thank you.
All right. At this time, you are being placed under arrest for DUI, okay?
Okay.
And I have to read a few things for you, but we can do that in the car.
Okay.
All right? Come on over here.
Whoa,
You
easy.
okay?
No, you tripped me. What the
Come on, you can't walk very well. That's the
No,
problem.
he tripped me.
He
What
didn't
the
trip
fuck?
you. Relax.
How many?
You were being so nice to me, and now you're yelling at me.
I am.
I don't need your stuff to be I'll fix your tie, okay? There you go. All right. ahead and have a seat.
The rearrest is handled without escalation. Deputy Evence calmly informs the subject she is being placed under arrest for DUI and places handcuffs back on, loose enough, by his own statement, to avoid the discomfort issue from earlier. The officers manage a clothing situation during the second arrest with professional discretion, a detail worth noting because mishandling it would have created an entirely different legal exposure. Then, during the walk to the patrol vehicle, the subject loses her footing and falls. She immediately alleges she was tripped. The accompanying officer denies it. The bodycam angle does not resolve the question. What matters legally is whether any force applied exceeded what was necessary to secure and transport a person under lawful arrest. Based on this footage, no clear intentional act is visible. If the subject sustained injury, this footage becomes Exhibit 1 in any civil claim. What comes next is the Miranda advisement. Under Miranda versus Arizona, once a person is in custody and subject to interrogation, law enforcement must advise them of specific rights before questioning begins. Deputy Evence is about to read those rights in full. The timing, the sequence, and the subject's response all carry legal weight. Listen to every word.
I gotta read you a few things, okay? I want you to pay attention, okay? You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before we ask you any questions. Do you understand each of these rights that I have explained to you?
Yes, I do.
Now, with these rights in mind, you want to talk to me about what's...
With Miranda advisement complete, and the subject confirming she understands her rights, Deputy Evence pivots to the hit and run. This is textbook custodial interrogation protocol. Rights first, then questioning. The subject, despite having just been read her rights, continues to engage. She denies hitting the other vehicle and offers the prior accident as her explanation. She even invites the officer to examine insurance records from the Mercedes-Benz incident. Deputy Evence clarifies that a separate officer is handling the crash investigation. His jurisdiction is the DUI. This division of investigative responsibility is standard procedure and insulates each charge from the other. A note on Miranda timing. Berkemer versus McCarty, decided by the Supreme Court in 1984, established that ordinary traffic stops do not constitute custody for Miranda purposes. A person temporarily detained for a traffic violation is not yet in custody and need not be read their rights before routine questioning. Custody attaches when a reasonable person would not feel free to leave, typically the moment of formal arrest. Here, the subject was formally arrested, placed in a patrol vehicle, and then advised of her rights before substantive questioning began. That sequence satisfies Miranda requirements. The timing was correct.
What's going on today?
I wonder why you calling me to the site.
Okay, well, we'll start with the hit and run. Okay. Over in the Petco parking lot, you hit a car. Okay. So you were seen by a person hitting their car. Okay. You have damage consistent with the damage.
Actually, I have damage consistent from my previous accident 2 months ago that I didn't fix. From Mercedes. I can testify to the Mercedes-Benz accident because I was hit 2 months ago. That is not true. You can testify and I can show you the records. I can show you if you let me put my phone.
I'm not doing the crash investigation. Deputy Klauser is doing the crash investigation. And what'll happen is you'll get the paperwork for that.
Yeah, that's fine.
But I'm doing the criminal investigation, and that's for DUI. You were seen driving a motor vehicle. I smell a strong odor of an alcoholic beverage.
Alcohol.
Emitting from your breath.
And that's what you assume.
No, I can smell it.
You can smell it. So your smell
you
is
told me,
for alcohol. I did not tell you.
You told me that you had some drinks at the time.
No, that's not what I told you.
Go ahead and slide your feet that way.
This is where the resisting arrest charge originates. The subject, already under formal arrest, already advised of her rights, attempts to exit the patrol vehicle and refuses to place her feet inside the car. An officer issues multiple warnings, explicitly advising her that continued resistance will result in an additional charge. She persists. Under virtually every state's resisting arrest statute, physical resistance to a lawful arrest, including refusal to comply with lawful commands during transport, constitutes the offense. The subject's assertion that she is not resisting does not alter the legal analysis. Resistance is defined by conduct, not self-characterization. The officers use minimal physical force in response. No strikes, no impact tools, no weapons deployment. The hands-on control used to position her feet inside the vehicle falls within the soft, empty hand control tier of the use of force continuum, proportional to the resistance encountered.
So, what
Slide your feet that way.
I said we trying to take you.
Yes, yes, yes.
Okay.
Slide your feet that way.
Okay.
All right, bingo.
I don't want you to open the door. I want you to slide.
Close the door. We'll talk about it.
No. Because if you
Put your feet in.
Put your feet in.
Jail.
You are going to jail. You're under arrest.
I'm not.
Okay. Put your feet in.
I'm not
If
resisting arrest.
you resist, you're going to catch another charge. So I'm going to give you one more opportunity.
Sir, you
One
said,
more.
You
Put your
said-
feet in the car.
What you said was, if I am...
Sit up. Stop being ridiculous. Stop. Okay? Relax. I'm going to
No.
sit you back up and we're going to shut the door. Okay? Relax.
Yeah, just sit up, please. We're going to have
Can you pull her over, Josh?
to put her.
All right, I'm going to shut this door and then we're going to have to kick her feet up. Good night.
I'm not resisting.
He's all right.
What are you talking about? What are you...
And we're going to have to pull her out and tarp her, it looks like.
Yeah.
I'm not resisting. What are you talking about?
Before this footage ends, there is one more moment that deserves to be heard without commentary. An officer approaches the son, who has been standing nearby throughout this entire encounter, and tells him what is happening. Some moments on Bodycam are legal exhibits. This one is something else entirely.
What's up, bud? Hey, I want to give you a couple updates on your mom. Okay, we've got her. She's going to be going to jail tonight.
Why?
Okay, she hit a bunch of cars in the parking lot, and she's real drunk. So, yeah. Is there anybody else that can come hang out with you, or are you good by yourself?
I'm good by myself.
Okay. Sorry to give you this news, man, but it just kind of is what it is.
The woman was charged with 1 count of DUI, 1 count of leaving the scene of a crash, and 1 count of resisting arrest.
The woman identified as Anastasia was charged with 3 counts: driving under the influence, leaving the scene of a crash, and resisting arrest. Each charge carries its own evidentiary burden. DUI requires proof of impairment beyond a reasonable doubt. Leaving the scene requires proof that a collision occurred and that the driver knowingly left without exchanging information or rendering aid. Resisting arrest requires proof of intentional physical resistance to a lawful arrest. The bodycam footage captured evidence relevant to all 3. What a jury ultimately concludes is a separate question. The footage, however, tells a story. At the time of this analysis, the full court disposition of these charges is unknown. A competent defense would attack on 3 fronts. First, the SFST battery was never completed, which weakens the DUI charge and opens the door to challenging probable cause for the arrest itself. Second, the vehicle damage predates this incident according to the subject, and if insurance or repair records support that claim, the hit and run becomes a credibility contest between the subject and eyewitnesses. Third, on the resisting arrest count, defense would argue the subject verbally objected but did not physically assault anyone, and that the force required to secure her was disproportionate to actual resistance offered. These are not frivolous arguments. They are the precise pressure points a defense attorney would apply. Whether they succeed depends on evidence, jurisdiction, and the jury seated. Deputy Evence receives a B+. The deputy conducted this investigation with notable patience given the subject's escalating agitation. The DUI investigation was initiated on legitimate grounds: odor of alcohol, observed erratic behavior, and multiple witness reports of a hit and run. The Miranda advisement was delivered at the correct procedural moment, before substantive post-arrest questioning, not as an afterthought. The reapplication of handcuffs with stated attention to tightness reflects responsiveness to a legitimate complaint. The handling of the clothing situation showed professional discretion. The force used to secure the subject in the patrol vehicle was proportional and within acceptable parameters. However, 2 areas warrant scrutiny. First, the DUI arrest was executed before the SFST battery was completed. That decision rests on observational probable cause alone, which is legally sufficient but tactically thinner than a completed test battery would provide. A defense attorney will exploit that gap. Second, the fall during transport was not followed by any visible welfare check. Best practice calls for a brief injury assessment when a detainee goes to the ground, regardless of cause. These are process concerns, not misconduct findings. Anastasia receives a D+. The subject's consistent denial of the hit and run is her right. No one is obligated to confess to law enforcement. Her early mention of an attorney reflects at least partial awareness of her rights. Her demeanor with Deputy Evence during the DUI explanation was, at moments, cooperative. These are positive marks. The The negatives are significant. She was operating a vehicle while impaired in a commercial parking lot. The witness reports, the vehicle damage, and the odor of alcohol collectively paint a damaging picture. She interrupted the SFST by announcing a phone call, eliminating the one opportunity she had to demonstrate sobriety on camera. Most consequentially, she physically resisted being secured in the patrol vehicle, despite multiple warnings, explicit, calm, and repeated, that resistance would generate an additional charge. It did. That charge was entirely avoidable. Resisting a lawful arrest does not protect any of the rights she was asserting. It compounds an already serious situation and eliminates goodwill that might otherwise be available at sentencing. The son's conversation with the officer at the end of this footage is a reminder that these decisions have consequences that reach beyond the individual being arrested. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out our second channel, Audit the Court, for even more police interaction and courtroom content.